Welcome to the Retzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Ericka Adler, shareholder and leader of the healthcare practice at Recruitment and Andrews. Today, I'm excited to have Laura Lauth Andrews joining us. Laura is the lead attorney with Lauth O'Neill, and she is a healthcare lawyer. She does a lot of the similar work that I do, particularly reviewing employment agreements for physicians and other healthcare providers and recruitment agreements as well. And so our topic today is really going to be about recruitment agreements. This is something that we don't hear people talking about very often. I often get calls asking about recruitment agreements. We once did a podcast on this several years ago, and people still sometimes call and ask about that one. So this is excellent timing because I've been seeing a couple of those come across my desk. And I know, Laura, you've mentioned you've actually seen an increase in these coming across your desk. So I think this is a fantastic topic, and I'm really glad you could be with me today.
Yeah, thanks for having me.
So let's start with having you just explain for everybody out there, what is this recruitment agreement? What is it exactly? And how does it differ from like just, somebody getting hired with a letter of intent or something like that?
Right. A recruitment agreement is a completely separate type of contract. We usually see them coinciding with an employment agreement. A recruitment agreement itself is generally a contract between three separate parties, those usually being a physician, a hospital, and a group, or we also might refer to it as a practice. So the recruitment agreement is essentially an agreement whereby a hospital is helping to pay for a physician's salary or to supplement their income in exchange for the physician coming to work in a certain geographic area. While the actual group or the practice will be the actual employer of the physician, the hospital will be, like I said, supplementing their income and providing that additional support to them. So you can also look at it as essentially it boils down to a loan agreement because it is money that it's not simply just paid to a physician with no strings attached. There certainly are strings attached to that payment. And the recruitment agreement itself will provide for a commitment requirement where the physician has to commit to remaining in a geographic area, providing services in their specialty on a full-time basis for a set amount of time. And if they don't fulfill that commitment, then they are, theoretically and technically on the hook to pay back all amounts that were paid to them or to the practice on their behalf by the hospital.
Right. Okay. So there's a lot of components in there. So let's break it down just a little bit. First of all, we're talking kind of about a three-party recruitment agreement here. Sometimes for those of you out there, you may have something that is, just with a hospital, and I've still seen it called a recruitment agreement. That may have a lot of similarities. So still listen and pick up on some of the things that we're talking about here. The other thing I want to point out is that in addition to compensation, a lot of times they are also throwing in things like the signing bonus. So the hospital could be giving money to the group for that, relocation amounts, startup amounts, things like, maybe renting a new office, hiring new staff, etc. And we're going to break that down a little bit. So I think you kind of gave a very good overview of what it is generally. I want to kind of explain a little bit about why recruitment agreements are so special. Not everybody can have a recruitment agreement, and they do need to be written in a very particular way. And I kind of want to have you speak to where we get this idea of the recruitment agreement and what the legal requirements are and kind of where those come from.
Right. As you said, recruitment agreements are special in a way, in the sense that there are a lot of compliance issues that we have to worry about. I would say, in general, a lot more than we have to worry about when we look at a general employment agreement. So when we look at a recruitment agreement, what we're worried about there, what our concerns are, whether it complies with Stark. Stark is a federal statute that civil, not criminal, but the repercussions, surrounding any violation of it can still be very significant. It is a federal statute that basically, the purpose behind it is to hopefully reduce physicians having their decision making unduly influenced by financial arrangements. And there are many exceptions to the Stark rule, and one of those is the recruitment exception. So when a physician is specifically being recruited to join an area, and that geographic area is supposed to be in need of that physician's specialized services, that is an applicable exception that allows for the physician to come there and have this portion, at least, of their compensation paid by the hospital. And so, and I think what the second part of your question was, what are the requirements
Yeah,
of
so
that?
right, exactly. So Stark, and then just to back up just a little bit, so Stark is generally a self-referral statute. So physicians cannot refer to an entity for federal DHS with which they have a financial arrangement. And so in all of these situations, we're talking about a practice that refers to a hospital for Medicare services or items that are DHS, which would be, hospital-based services, right? So we have to have all those components present. So if you're just like I don't know, and the kind of a cash-based practice, you're not billing Medicare, it's not DHS, whatever, and somebody's talking about a recruitment agreement to you, you should be able, after listening to this, to be, I don't think that applies to us, right? Or if the kind of, if there's no Medicare, you only do private pay, oops, Stark is not going to apply. So the recruitment agreement doesn't need to meet the requirements that you're about to describe. So just, the people listening, some people know more than others. So just want to make sure that everybody doesn't walk away thinking that these are the requirements they all have to meet. So just to be very specific, Medicare and DHS are required in order for what Laura is about to tell us to apply. All right, go ahead.
Yeah, and thank you for those clarifications. Yeah, so when the Stark law does apply, and then we thereby need to meet an exception to have a proper compensation arrangement, here are some of the requirements that need to be found in that contract. So first of all, as I mentioned, the community in question or the geographic region must be considered in need of those services that the physician requires. And I think we discussed this when we initially spoke. I often see this outlined in the recruitment agreement from the very get-go. A lot of hospitals will sort of cover their bases and say, the hospital has determined that the community is in need of XY services that the physician requires, and that physician is able and willing to provide those services and fulfill that need. I think you had mentioned to me that, you wouldn't be so terribly concerned if those exact words and language weren't provided in the agreement, so long as it is true that that community is in need. So that's something to think about.
Mm-hmm.
Another requirement, like I said, it's called the recruitment exception. So the initial intent and thinking behind it is that the physician is supposed to be newly recruited to the area, meaning that he or she is coming from a different geographic region. There are a couple exceptions to this as well, for physicians who are, I believe, only 1 or 2 years into an employment setting out of training, that they don't necessarily have to be new to the geographic region. So there's some wiggle room for exceptions there as well. The agreement must be in writing. It needs to be a written contract between the parties. Um, there are very strict approaches to whether the physician can be restricted in terms of providing outside services. So the physician has to be allowed to establish privileges at other hospitals or healthcare facilities and refer patients elsewhere. The hospital, can't say you're not allowed to do that. And then the employing practice likewise cannot restrict the physician from doing so. And so that's when the issue of a non-compete following employment comes into question. Because like we discussed initially, there is that commitment requirement. The commitment requirement is with regard to the community and not with regard to that specific employing practice. So once that employment potentially terminates, the physician likely needs to continue providing services in the area. So therefore, their employment can't be restricted.
Right. I'll mention, though, that this has changed over time. There was a clarification that there could be a restriction as long as it was reasonable. So originally, I've been doing this a long time. You never saw any non competes because everybody was like, oh, you can't have any non competes. The doctor has to be able to serve the entire area. Now you can have a reasonable non compete. I would argue as to whether some of the non competes I see are reasonable, but the idea is that the non compete is still smaller than the entire service area, right? So we very often see recruitment agreements and shortage areas in rural areas, right? So maybe you would have to go 50 miles away, to really, kind of, let's say, find another job, right? And the service area, let's say, is 50 miles. So they'll put maybe a 30-mile non-compete, right? So
Mhm.
the idea is it's not the whole service area, but it's big enough that somebody who's maybe has a home and a family is not going to want to go that far. It's a little bit of a tricky area. I wonder if they'll go and take a closer look at that as as time goes on when it comes to analyzing stark the stark rules as it relates to recruitment. But I don't know what you've seen on that.
Right. And it would be, certainly helpful because the term reasonable, what does that really mean to any of us? And of course, depending on the circumstances, it's always going to be different. So that can be a tough one.
Hmm.
Another requirement that you had touched on initially is in terms of the compensation arrangement, the payments being made by the hospital on behalf of the physician, they really need to be limited exclusively to cover the practice's incremental costs of employing that physician. So that can also include those recruitment costs, like you talked about, relocation, a signing or starting bonus, and then also supplementing their salary. So, in other words, what we want to look out for there is that the practice isn't really, having their bills paid otherwise by the hospital. The hospital shouldn't be keeping the practice's lights on, so to speak. It should really be the incremental costs directly associated with employing that physician. Um, Another aspect to consider is that the um, compensation arrangement is supposed to be set out in advance and, like we said, in writing. And so that sort of leads you to the conclusion that it can't be modified. The compensation approach can't really be modified once this arrangement is underway.
Okay. Yeah, I think, and generally the recruitment agreements I see typically are fairly standard in that they have these requirements in there. Whether they're following them, I don't know, but they all have them in there. So I think those are pretty standard. As you mentioned, when the doctor goes to work there, the doctor will typically, let's say, there's always a period where they're getting support. And then usually the support period ends, and then there's a period of forgiveness, right? So it could be, let's say, 1 to 2 years of getting support, and then 1 to 2 years of getting forgiveness. Now, I always think it's ideal to keep the support period as short as possible and then the forgiveness period, because even if the doctor is going to stay there and it's going to end up being like money for free, right? It's good to get it taken care of. Like, you don't want that hanging over you in case something happens. That whole concept of the forgiveness over time, et cetera, is not something that's actually part of the law. It is become the way in which it is written as a standard across the country, but it is not required by law. And yet it's interesting because everybody kind of does it almost the same way. And so typically what I see is that every month the hospital is supposed to turn in a statement to the group is supposed to turn in a statement to the hospital saying, this is how much the doctor brought in, and this is how much we've agreed, would be the base monthly amount, right? And so the difference is X amount. So the hospital then is supposed to turn over that amount. So you might be imagining the people out there that the hospital's just writing like a huge check, right? Um, that may be true for the startup costs of things like, malpractice and a signing bonus, et cetera. But when it comes to the actual support, they really are supposed to be getting a report from the group on what the doctor's collections were, what the deficit was between what the doctor brought in and what they hope to give the doctor as a base salary. And then the hospital makes up the difference. So you really won't know until the end of the support period exactly how much money has been borrowed, so to speak, right? And I always like to put in, I don't know if you do this as well, that as soon as the doctor's collections are really kind of at the support level where the group is not needing to ask for support, that we have the right to end the support immediately so that forgiveness starts, because sometimes it could be like a 2-year support period, but by 8 months the doctor's there, right? And so
Right.
I forgiveness to end. The other interesting thing is, and this is probably appropriate, is sometimes if the doctor's collections are more than what that monthly amount is, the group has to write a check to the hospital and give that money back. So we certainly, it's better to just end it. Is that typically how you're seeing them set up as well?
I don't typically see them set up like that right off the bat, but like you said, that is something that I would always, sort of aim to achieve. Like you said, if a physician is very productive and has, very quick ramp up period, and they don't, and the hospital isn't really kicking in very much money um after just a short amount of time, then it's certainly in the physician's best interest to go ahead and terminate that relationship and then work on the forgiveness aspect of things to just sort of get
Right.
things going in the right direction so he can be done with that liability.
Right. And so I think everybody kind of understands how these are set up. What I want to talk about now is what happens when things don't quite work out right. Okay. So I mean, we talked about the idea that you mentioned this is a loan, right? In a way. So until that forgiveness period has ended, what do you see happening if the doctor is not there, or the doctor is not there full time, or the relationship between the parties ends? What have you seen happen?
Right. I mean, there's so many ways that an employment arrangement can terminate or, go sour. And that's what we are always reminding clients about, the fact that, what if the practice lets you go? Or what if you die? What if you become disabled? For women, there's the question of going on maternity leave and therefore not technically working on a full-time basis. There are all these different ways that a physician might have his employment terminated and then still, have that responsibility to the community by virtue of the recruitment agreement. So we have to think, are you going to be able to continue working in this area? Are there other practices that you could join, or could you start your own thing up? Um, oh,
Right.
sorry.
Yeah, no, absolutely. So let's break those down just a little bit. So, one of the things we want is that if you die or become disabled, I like to see the money forgiven completely. Okay. If the group decides to let the doctor go or reaches that agreement, I need to know from my clients that this is the kind of job where no problem, I could start my own practice or I could find another job in the community, right? If I hear from my client, oh no, this is, I couldn't practice what I practice there, or no, that's not really possible, then I become alarmed at the idea that they're signing a recruitment agreement. What will happen? And I've had this happen where the relationship doesn't work out and the doctor has this huge loan. They can't stay in the service area. They have a non compete. And even if there wasn't a non compete, there's nowhere else to go to practice, right? And that assumes that the agreement says that the loan can be, as long as the doctor stays in the service area, that the loan will continue to be forgiven. They don't always say that. So that's one thing to make sure we're looking for. So what do we do other than what I do is to tell my client, I would rethink signing this. Okay.
Right.
The only other thing I can really think of is to make sure that the group is going to indemnify the doctor for that loan amount, or the hospital will agree to only go after the group because the group has all the AR and everything, right? If the relationship ends between the group and the doctor. Now, obviously, exceptions to that would be the doctor choosing voluntarily to just walk away, or the doctor doing something pretty bad, right? Where they get
Right.
terminated. But those are the only solutions that I can really think of. But that's the one situation that really worries me.
Right. Yeah. And I'm always telling clients, let's say the situation, the employment relationship terminates for a reason that is entirely out of your control, which we just named many of them. Another aspect that we had touched on earlier is if the group, you know, fails to provide the requisite financials and documentation in accordance with the hospital's requirements to determine the payment amounts, or they don't hold on to the records in the way that they're supposed to, that would likely be considered a breach under the recruitment agreement. Again, entirely out of the physician's control. So in that type of circumstance, who is going to be the party responsible for the repayment. So like you said, oftentimes the most we can do is, advise a client against signing it, or, attempt to negotiate it. So we have whittled down the instances in which the physician himself or herself will be the responsible party for repayment.
Right. And I think that's really key. That's what we spend most of our time when we're looking at these documents trying to do. So you might look at a recruitment agreement, it might sound very reasonable to you. It may say, oh, doctor and group are responsible to repay, doctor and group, And then when we get the employment agreement, it'll have a provision there that says if the hospital comes after the group for any money, the group can look to the doctor and the doctor's on the hook for it. Like you got to really watch out for provisions like that, because they're pushing all the blame or all the responsibility onto the doctor's shoulders. And I see that almost every single time. I assume you do as well.
I do. It's sort of a catch-all to
Right.
say, we don't have the responsibility here.
Right. The other thing that concerns me about recruitment agreements, and I've seen this happen quite quite a few times actually. And I don't want to call it a scam, but there are groups that go from recruitment agreement to recruitment agreement to recruitment agreement. I don't know whether there's a true shortage in the area or not, but they do recruitment. It ends with one doctor, they go to another recruitment agreement. So they have an ongoing relationship with the hospital that's very, very close. The concern when I see this is A, whether there's a need in the community at all, but B, the problem is that the doctor, is guaranteed a certain amount of compensation, while that support is in place. When the support period ends, the doctor then, as we've mentioned, stays in the community until the forgiveness is earned. Their compensation formula at that time often changes. Maybe they were on a base salary and now they're moving to productivity or something like that. Once they're out of the support period, all the hospital cares about is that they stay in the community and get forgiveness. What I have seen happen sometimes is suddenly there's not enough work for the doctor to do. The doctor's revenue drops. The doctor's not busy enough. How could this be when there's a shortage in the area? And sometimes I've had doctors that are just not even earning enough to live on, and they don't know what to do. And it always mystifies me, this particular situation. How can this happen? How are they so busy during the support period when that money's flowing to the group and the group is getting the money and the group is billing for the doctor's services? And then the minute the support ends, suddenly they don't have enough patients for the doctor to see. I don't know. Have you seen that happen?
Well, I think it's to your point about practices and, certain practices, like you said, get in the habit of having recruitment agreement after recruitment agreement. And you have to go back to, what might be motivating them to enter into these relationships. So when a recruitment agreement is in place, the practice itself is really achieving a significant benefit in the sense that they get to employ this physician who, in most circumstances is very highly qualified and specialized. But they're not having the burden of paying his full salary. They're having that kicked in by the hospital. So it really is beneficial to small practices. So, that might be sort of an inappropriate motivation behind why they are entering it into them so frequently, and sort of ignoring the requirement of the community being in actual need of that physician's services.
Right. I think that's a great point. And so I think it's hard to prevent that situation from happening. What I try and do is say that, either lock in the base through the end of the entire support period, try and end that support period as soon as it's not the end the support so the forgiveness can start, because the doctor's stuck in that community, right, until they can leave. Sometimes I see a provision that says that, if the doctor leaves, but they're able to recruit a new doctor into that doctor's shoes, that's okay too. But if they don't have the support at that point, like let's say it's the forgiveness part, not the support part, they don't have the money. So the best thing to do is really try and lock in the compensation until the end of the forgiveness period, right? Or say, okay, I'll switch to productivity, but my floor is the base that I was receiving or something like that.
Right.
An impossible situation sometimes.
But more often than not, right, you're going to have a situation where the practice is saying at that time, your compensation will be determined by a compensation methodology in place at that time. So I think it's pretty rare and tough to get them to commit to that long term.
Yeah.
guarantee or base.
Right. And really, I like what you said. The hospital obviously has money. The group, this is almost a risk-free arrangement for them. And then if the doctor leaves, they have all the AR coming in anyways, and the doctor's on the hook. The only party that's truly, truly at risk here is the doctor.
Right.
This is a risky arrangement. And I don't care how nice the hospital people are and the group is and how much you like visiting them and how wonderful they seemed. This is a business arrangement that you need to go into with your eyes open, and you need to understand all the potential risk. And so many young doctors, because usually this is people coming out of residency and training that are signing these recruitment agreements, they're naive.
Mhm.
And what's the number one mistake they make? They don't talk to a lawyer before they sign it.
Right. And to that point, I'll just harp on that a little bit more in terms of, the physician really being the one who's taking on the bulk of liability here. I've seen more than once, more than a handful of times, physicians that I've worked with that they have me review their employment agreement and certain, words and provisions in that. Sometimes the employment agreement does refer specifically to a recruitment agreement. Sometimes it doesn't. Um, but based on how it's outlined and structured and certain words in there, I come back to the client and I say, is your salary being paid for or supplemented by a hospital? Is there a separate arrangement in place here? And they say to me, oh yeah, they did mention something about that, and I'm going to have a different contract to sign after I sign this one. So in those circumstances, it's very obvious that the employer essentially is trying to sneak one over on them by not even letting them know that they're entering into a technical recruitment arrangement. So, even scarier that the physician himself or herself doesn't even realize the arrangement that they're entering into. They oftentimes, if they're not having someone like us take a look at it, they're not realizing the significant and far reaching repercussions associated with it, the huge liability they're taking on.
I absolutely agree. I mean, imagine, 500, 600, $800,000 hanging over your head. I don't know how much money it ends up being borrowed at the end of the day, but add to that the incremental costs, the startup costs, the recruitment, the relocation, we could be talking about a significant amount. So if things don't work out, in the worst case scenario, the agreement didn't get fixed, the doctor is let go without cause, can't, there's nowhere else to work in the community. um, what happens? I mean, at that point, the hospital can call in the loan on the doctor. The doctor typically signs a separate promissory note, and the hospital can go to court to try and collect. And I have had this happen more than one time to my doctors. And it's never because the doctor chose to walk away and not honor their obligations. Have you had that happen yet to you?
Thankfully, no, I'm knocking on wood right now. I haven't been directly involved in a scenario where the physician is actually, facing that down and having, a hospital system come after them for the money. It's one of those things that so far in my experience and career, I've only been on the side of sort of warning against these scenarios and trying to avoid them. But I can only imagine. And then I think that goes back to some of the things we touched on earlier about some goals and most important aims that we can advise clients to negotiate. And one of them would be, if it does hit the fan, so to speak, let's make sure that if you do have to pay the money back, it's in the most reasonable, practical, doable way as possible. So that would mean negotiating installment payments versus just one lump sum, for instance, because who can pay that amount?
Right. Absolutely. And I mean, if it's, you should make sure you have disability insurance, make sure you have life insurance to protect your family, because I have seen hospitals totally willing to go after a doctor's family. Right. The other thing I want to emphasize is that because these are young doctors, this debt is in addition to medical school debt they may be carrying as well. So this can be an overwhelming burden for a doctor to have to carry. Um, what has happened in a couple of instances in the past is, you know, the situation leading to the money being due has been questionable to us. It didn't appear there was truly a shortage in the area. suddenly there's no work to be done for this specialist because the support period ended, things like that. Or we became aware that there were actually a whole bunch of doctors doing the exact same thing in the area and there really was no shortage. So what we have done is sometimes send a letter to the hospital claiming that we believe it's a Stark violation. That won't always work, but in some cases it has where the facts support it. It's better to note a potential Stark violation before you sign the agreement and not have to use it, to try and get someone out of a huge repayment obligation. But certainly, if the facts are there, you can use them to your benefit. So that's something you can also talk to your lawyer about. So I would say at the end of the day, the doctor's team, of course, needs to include their lawyers, right? But you also need to be talking to a financial advisor, can help you understand what this loan looks like, what protections you might have in place to assist you and your family should something happen, um, to help, you really understand the financial implications.
Right. And just some of the basics about the tax liability and when that actually becomes due, because, under a promissory note, a loan arrangement, it might not be considered income for tax purposes, right? When that money is paid to you. So that's another thing you definitely have to discuss with your tax preparer or financial professional.
Yeah, that's actually a great point. So for a lot of these loans, it is considered taxable income as it's forgiven. So it'll
Right.
as taxable income, like could be over 2, 3, 4 years, whatever the arrangement is. If you have to pay that money back, right, and you already paid taxes on that money, it can get super complicated. Some of my tax partners have dealt with this for some of my doctors. And the funny thing is, especially because some of these are not sophisticated hospitals, they could be small rural hospitals. They don't necessarily report things properly either, not intentionally, but just from maybe a lack of knowledge. So it can really turn into a mess. So you definitely, great point, need good tax advice, which I am not the one to provide. I don't know if you are, but I'm not.
I am not the one.
We know when to send you to somebody else, right?
Right.
Good CPA, good tax preparer,
Yeah.
financial planner, lawyer.
It's a skill to know how to delegate. Right.
Yes, delegate and collaborate, right? So,
Right.
perfect. All right. Can you think of anything else you want people to know about these agreements?
Well, one thing I was thinking about when we were just discussing, the huge liability being on a physician individual's shoulders is, and I was just curious if you've ever attempted this or done this yourself, but whether there might be a scenario where the hospital and or employer are willing to include a sort of overarching indemnification provision that specifically relates to compliance with Stark. Um, because in my viewpoint, I'm thinking, they're the ones with all the resources. They're the ones drafting these contracts. They're the ones coming up with the compensation arrangement in the first place and offering it to the physician. So, my argument is certainly that it should be on those entities to ensure compliance and that everything is done appropriately. So I just wondered if you've ever seen, entities sort of assume responsibility for that right off the bat.
I haven't, but typically what I do see in a lot of agreements is a representation and warranty that the agreement has been written to comply with federal law. So that's one thing. Secondly, what I try and get in there is that if the breach of the agreement or the representations is by the hospital, that the hospital is going to be the one, that's going to forgive the amounts, not come after the doctor. So we try and go about it in a roundabout way. But I definitely haven't gotten like a specific statement that, if this doesn't comply with Stark, we're going to be on the hook, and it's not a bad thing to think about. I think with smaller hospitals, I don't know how familiar they are with Stark, even though they're using a recruitment agreement. I don't know if they would agree with that. The larger hospitals tend to use a single form. I've seen the same form from many larger hospitals. They won't negotiate any
Right,
document.
like the HCA form, and you can pretty much trust that they're doing it properly.
I would hope so. Uh,
Yeah.
no,
Yeah, I exactly. You would hope so. They certainly have the resources to consult compliance experts and make sure it's done correctly,
right.
but I guess you don't know for
And
sure.
Stark is a pretty big deal. It's a black and white law. There are lots of implications to violating it, and I think everybody, wants to comply. But I think, some people are a little bit lax. They see this as a way to give free money to bring doctors community or for groups to get free money. And I think, it's that kind of unsophisticated perspective that doctors need to watch out for, because they are just going to become the unknowing victim of people who are just not educated enough in this area. So I hope you and I can serve the purpose of helping those doctors before they sign. And we're not saying not to sign, but we're saying let's make sure it's as good as it could be before you sign, and the risk that you're taking. And for anybody listening out there, if you get one of these agreements, someone is getting one, please urge them to talk to a lawyer. You can reach out to Laura or myself with any questions that you have. We're happy to answer them. And hopefully, this discussion has been helpful to someone, right?
Absolutely. And I would say, again, just there's absolutely no shame in seeking counsel on these issues. I think that can be a little bit of cause for hesitation for physicians. They often, they're being offered this big salary and they don't want to ruffle feathers with their future employer or the hospital that's going to be paying a part of their compensation. So oftentimes they feel just wrong in saying, I want to take my time to review this with a lawyer, but there is certainly no shame or anything wrong with doing your due diligence. And I would say if you are dissuaded or discouraged from consulting an attorney, that's probably a significant red flag.
Absolutely. That's a great point. And not just when it comes to recruitment agreements, but any, right? When they rush you, they sometimes just don't want you to look too closely, right?
Right. I never like a quick or strict deadline. And I generally say, you should just ask for a little bit more time. And if they're not willing to give you that may be a problem.
Great. All right. Well, great advice. Thank you so much, Laura, for joining me today. If anybody out there has questions, feel free to reach out to both of us, and I will post Laura's contact information as well so that you have it. You can reach both of us. This has been the Health Law Hotspot, and we hope you'll check out our other podcasts as well at ralaw.com. And we'll see you next time. Thanks for joining us.
The Retzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Retzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Retzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.